All right. Good morning, everyone. This is the Indiana Interstate Compact State Council meeting for Friday, June 25th, 2021. I'd like to thank you all for taking the time to participate today. I will say that right now we are still short our DCS proxy and Devin McDonald from the Indiana Criminal Justice Institute. So we are one under our quorum at this point. The only action item we had was to approve the minutes, so that's okay. It's on there as the second item on the agenda. Go ahead, take a look at them. If they come on, we'll go ahead and approve them this meeting. Otherwise, I'll just bump that to the next one. But if there's edits or changes, just go ahead and let me know. But then we'll go ahead and proceed right into the substantive presentation portion today. And we have Nita Wright as our sole staff member presenting on adult and juvenile compact. So Nita, I'll go ahead and turn it over to you. And if you want to go ahead and cover those items for me. You're muted, Nita.
Good morning, everyone. During the usual course of business in processing the cases for the adult compact, we came across a warrant that was not in compliance with ICAO standards, in which all interstate warrants must contain full extradition, be inputted into NCIC, and have no bond entered for that offender. So while we found one warrant, we usually can assume that if there's smoke, there's fire. So what we did to be proactive, we asked all of our 92 counties to do a self-audit of any warrant that was issued and still pending for out-of-state offenders. And in the course of that audit, we did find a couple of warrants that were not in compliance, and we gave the county 24 hours to cure the non-compliant warrants. All of those were cured within the 24 hours. There was only one that needed a little bit more time, but it illuminated the need for us to continue to offer yearly trainings to our counties due to turnover, new judges onboarding, just to kind of reiterate and to continue to keep to the forefront the rules of the compact, knowledge of the compact, and its procedures concerning the offenders crossing state lines, retaking those offenders, and those issues related to the warrants for retaking the offenders. So although we did find a couple, considering we have 92 counties and we have thousands of cases across state lines, that was really, really good to find just that minimal amount of warrants that did not meet compliance. Although one is too many, we do appreciate that our counties are overall heeding to compliance, and continuing to self-audit and run our own reports is essential. The Interstate Compact National Office, the Executive Committee, released a white paper for regarding remote hearings. Because of the pandemic, the increase of remote hearings was, because of the pandemic, remote hearings increased. It was already a concern how those remote hearings impact interstate cases prior to the pandemic, but the pandemic illuminated some of the concerns that were already present. Those being, how does it affect offenders who are already in a receiving state once they are sentenced? Because the ICAO's rules indicate that no offender should already be in the receiving state prior to their acceptance. So there was a concern specifically for sex offenders and a concern for absconders when conducting remote hearings. The white paper illuminates and impresses upon us that the ICAO's rules have the effect of federal law, and that as a member state, we are bound by those rules and laws, and we are to effectuate those rules. So keeping that in mind, anytime new proceedings or new procedures in individual states are implemented, our number one goal is to remain in compliance with those federal rules and to continue to process our cases in compliance with those rules. With that being said, The white paper addressed some of the common questions that the key stakeholders had when sentencing offenders remotely. One of those concerns was sex offenders, per the rules, are not allowed to be in the receiving state. If they are sentenced in the receiving state, are we violating or are we creating a loophole for states to get around allowing offenders to remain in the receiving state when they're not supposed to be there in the first place? Because the rules do not apply prior to sentencing, they are not in violation, and the rules were carefully written to take into consideration situations where offenders are already living in the receiving state. So the white paper addresses how the remote sentencing does not violate our rule 3.101-3 that indicates no offender shall be allowed in the receiving state prior to sentencing. It indicates they should not leave the state. So offenders who are actually sentenced in the receiving state have technically never left the state. So one could reasonably assume if we are operating um, a system of communication, which is the intent of the compact to ensure safety and those things necessary to promote community safety, those procedures necessary to ensure what's in the best interest of the offender. If we are continuing to keep an open line of communication, even if things appear to circumvent the compact, our communication and our goal is always to ensure the process is cognizant of the community and to ensure we are in compliance. So no, allowing offenders to be sentenced remotely does not violate the compact because it was written to already have protections in place for any type of offender. We would not just single out a sex offender. Another concern that was addressed in the white paper was sex offenders who are already living in the receiving state and their residents may not be compliant. That's a concern. But as with any other offender, and ensuring we are not singling out a type of offender, a normal offender that was sentenced in their home state would have the opportunity to relocate or find a suitable residence. So we are to continue our communication, continue to expeditiously help the offenders to get the appropriate um, placement and continue with processing their cases to bring them into compliance. So overall, the white papers address and illuminate the concerns that were already present with the pandemic, remote hearing, and other technological advances that are now present will continue on even after the pandemic. And so this, along with other questions that may arise, it was just a way to express how we are to continue to keep our communication open, keep in mind the purpose of the compact, and not to allow those smaller nuances to hinder the overall purpose of moving these offenders across state lines safely, quickly, and keeping our community safe.
Nita, can I jump in for just a second?
Yes.
Some of you probably know that the court is looking at its administrative rule that governs remote proceedings right now and coming up with a revised version post-pandemic. I think some of you have already submitted feedback from your different constituent areas on some of the needs and issues you've seen. But Jenny, because you staff the rules committee, could you make sure this white paper gets to them for their consideration as they start looking at what that future rule needs to look like? Thanks. You may need to explain it to them and why it matters that we don't get crosswise with it.
Yeah, good idea. Thanks.
Is it anybody who sort of engages in those? Do you have any questions before we move on from this one? If you see anything in that white paper that you think could cause an issue here in Indiana with how we're doing business or how you think remote proceedings are going to go in the future, please let me know and we'll make sure that gets to the rules committee in the court before we revise AR 14. So thanks, Nita. Keep going.
Due to the pandemic and the financial concerns and safety concerns of all constituents, the annual meetings for both the adult and juvenile compacts are being held virtual again this year. I presume this may be the last year that they are virtual, considering all remains well. The Adult Compact Annual Meeting will be held September the 27th through the 29th. And the Juvenile Annual Meeting will be held October the 4th through the 7th. And it would be wonderful if any of you are interested in joining us, that you join us to experience that firsthand training that's available to us as the Compact Office.
Can you send out the invites, Nita? I went to the annual meetings a couple years ago, and they were pretty informative as far as some of the training scenarios they give folks, just to understand how the system works in a more micro level than we tend to be able to discuss it here. So
Yes. And lastly, I would like to highlight on the juvenile side of the Juvenile Compact. We are pleased to know that Unity is officially up and running. JIDS retired on May the 12th. We do have access. We have a 1-year access for historical purposes only, but we do have access to all the cases that were originally entered into our old system. On May 19th, Unity rolled out, and we continue as a state with our onboarding process. We have 204 users. Of those users, as of last week, we had 46% compliance with getting them logged in and completely done with the new trainings that were released. So keeping in mind, we were supposed to roll out in December. So a lot of counties that had completed those trainings, they had additional trainings roll out really quickly, several trainings per week. They're still doing the onboarding process because all 92 counties were required to take these trainings to ensure that not only are they operating proficiently in the system, but that they are also have an update and refresher of the rules and those things changing with the rules. So overall, even though we have about 46% to close to 50% on the onboarding process, we only have 204 users. So that's still close to half of our users, which we have 92 counties. So that's considering that that's pretty much 1 user per county. So that's very good. So we continue to work on that process, work on enabling proficient users. The more proficient a user is, the better it is for moving our cases expeditiously. So we are very proud to announce that it rolled out very smoothly, that any type of issues are being handled behind the scenes by the vendor. And it's really a very positive system. I've received nothing but positive feedback. And the same thing that has been announced from the national office, that the positive feedback overall is overwhelming. So we are happy about that. And that's pretty much all of our updates for the interstate compacts. We continue to move forward with the new progression of the dashboard trainings for compliance, and we will start those in July. And each quarter we will participate in an area, a specific area of compliance, and we can update you later on how that goes.
thank you, Nita. Anybody have any questions for Nita on the adult or juvenile updates? Great. Mary Kay, do you want to take us through the rule amendment process?
Sure. Every other year, so every odd year, both the adult and juvenile interstate compact, the national offices, the national councils entertain or consider rule amendments. So 2021 is a rule amendment year for both adult and juvenile. I happen to be a member of both of those committees. So I'm a member of the Juvenile Rules Committee and I'm the chair of the Adult Rules Committee. So a few weeks ago, you all received correspondence from April regarding rule amendments that had been posted for proposed rule amendments that had been posted for public comment. And those have gone through the comment process. Though both the adult and juvenile rules committees have met to consider those comments. I can tell you that there are some amendments that are being made to those rule packages for both the adult and juvenile side as a result of those comments. One of which was one that was Justin passed along to me regarding the definition of absconder on the juvenile side of things. And so Justin, your feedback was very well received by the Rules Committee, and it was incorporated into the process. Justin's proposal was to remove any requirement to prove or to demonstrate intent on the part of the individual to be away from the law enforcement or the supervision of the interstate compact or the local probation or supervision agency. So again, it was very well received, and so that will be reflected in those rules that are posted for final or posted for a public hearing, likely in August. And then there's a number of other juvenile rules that are being proposed. Our office indicated to you all as members of the State Council that our compact office is in support of those rule changes on the juvenile side. But there is a formal process which we need to talk about, the scheduling of that this council will officially review those and then direct me as Indiana's commissioner to vote at the annual business meeting on these rule changes. So that will occur for both the adult and the juvenile side. And we'll talk a little bit more about that in the process or later in this meeting. Also on the adult side, there are fewer changes on the adult side, but there is a pretty significant rule change that's being proposed this year. Nita mentioned earlier that we struggle nationally with compliance with warrant timeframes. And so one of the things that we are proposing from the Rules Committee is to bring some consistency to the adult rules surrounding the timeframes during which states need to issue compact compliant warrants, meaning federal, like national extradition and no bond within a certain time frame. This is actually a little controversial in the sense of some states struggle with or say that they struggle with being able to get these warrants issued in a timely manner. Depending on how their community supervision works, usually the Department of Correction doesn't have any issues with getting their warrants issued. But when you have community supervision or probation as a judicial function, it's a little more challenging sometimes, especially in states where it's a non-unified system. So we in Indiana have certainly had some challenges around this, but Nita has talked about how our staff is engaged with the locals to be able to make sure that we stay in compliance, or that we get into compliance when we identify problems with some of our warrants. So the Rules Committee feels pretty strongly that this is really in pursuit of public safety. The time frame that's being proposed is a 15-day time frame across the board, and which, in effect, it's 15 business days, which in effect is about 22 actual days, which we think, as do hopefully other commissioners in states, this is a very reasonable amount of time in which for any jurisdiction to be able to issue a compact compliant warrant. What we see sometimes is a breakdown in not only the warrant being issued by the court or the terms of the warrant being compliant with compact, in that they are national extradition with no bond, but sometimes those actually getting entered into the system is challenging. So we really need to work with all of our criminal justice partners at the local level, whether that's prosecutors and sheriff's offices and those kinds of things, to make sure that we're in compliance. So that's really the only rule that I think is, it's possible that this rule may not pass. We think we got support from key states who had previously voiced some concerns or objections around that. And the way that we address those concerns is that, on any given day, Indiana could be not in compliant with a warrant, but by and large, we generally are. And we want to make sure that every key player in the system understands what the requirements are, and that we provide the support necessary for them to actually be able to execute this requirement. And sometimes that's training, and sometimes that's technical assistance, and sometimes that's us making phone calls, or I may reach out to Chris and ask him to touch base with a prosecutor in one of the counties and those kinds of things. I think it's kind of an all hands on deck effort to make sure that we stay in compliance with this, but it really is, in the interest of promoting public safety. So hopefully that will all happen, that will all go as planned, and that rule will pass. It will be a lot easier for training purposes, so that we don't have to distinguish between, okay, well, I have to issue a warrant now how many days do I have to do this, or who needs to receive notice in what period of time, and those kinds of things. So we'll bring some consistency. So between now and the time that we have the annual business meeting, Justin, this group will need to convene again so that those final versions can be reviewed by this group and that you all can direct me to vote on those. And then Jenny, I would defer to you to see if there's anything from a process perspective that this group needs to consider between now and the time that we have that meeting.
Okay, I can't think of anything. So I think we'll keep an eye on when the final meetings are and make sure we get everything done in time.
So Justin, unless members have questions, that concludes my report on the rules.
Any questions for Mary Kay on those? Otherwise, it's on here. It says TBD on the agenda on a September meeting. We'll talk about that, but we'll get a meeting to discuss those proposals more in depth. Okay. Thank you, Mary Kay. Angie, you want to cover the NCIC access?
Sure. Sorry. So I reached out to Lieutenant John Carmen at ISP, who's been helping us with the access. We have where we can call in now to check on warrants and have that in place. That was our short-term fix until we could get a terminal of our own in place. And so Lieutenant Carmen has sent me the agreement, agency agreement, and the security personnel security clearance request for each person that would be using that. So I've sent the agency agreement to Diane Maines to review to get that moving, and then we will be meeting to get all of the information necessary. Each person that would need access will have to have an individual security clearance request. They also sent us letterhead on which with the actual terminology we have to use to submit those. So our next steps will be completing those, looking at the contract or the agency agreement, and moving forward with that. That's all I have right now.
And
Thanks.
Justin, if I could just, I'm sorry, if I could just add, I think we've been really grateful for ISP support on this. It was a much easier process than we had anticipated. So we just want to say, publicly to whoever may be watching, thank you to Lieutenant Carmen and his staff for assisting our staff in accessing this. So it's been moved very smoothly so far.
Great. Anyone have any questions on that? Okay. Does anybody have any other business, staff or members? Perfect. Hearing none, the 2021 business or meeting schedule is on there. The next technical meeting, because we meet quarterly, would be in October. But as Mary Kay mentioned, we do need to set up a meeting in September. So you'll see April send out a meeting poll for that. We're going to try, I suspect at that point, to be able to do it in person, as well as our future meetings, assuming no conditions go backwards on us. Probably over here at our Capitol Center office, but we'll be able to get that location out. Depending on where we are, if people are unable to attend, we might be able to set up some sort of hybrid call-in. It is difficult to do a Zoom and in-person meeting, I think. So we're going to try and do it all in person to the extent folks can make it. So you'll get a poll from April. If you could just give her some dates you're available on that, and we'll get the September one set up. So that is all I have. I think that takes us to the end of the agenda, unless someone else has anything else. We don't have a quorum, so I don't even know that I can take a motion to adjourn. I will just officially hit the leave meeting button. But I thank you all for your time today. And we'll see you, I'm sure, around.
Thank you.
Thank you.